We are here at the 11 o'clock session for oral arguments at the 5th District Court of Appeal. My name is Rand Wallace. I'll be the presiding judge this morning. Along with me on this panel are from Marion County Judge Brian Lambert and from Seminole County Judge Eric Eisnagel. We have the Baldwin versus Harris et al. Cases, and I'm going to assume the appellant would like 5 minutes of rebuttal unless I hear differently. And I would just ask counsel, when you're not speaking, please have your microphone on mute and or make sure you have if you have any devices that make noise while you're speaking, please make sure those are on mute. And with that, Mr. Fryan, I will go ahead and you may proceed.
May it please the court. My name is Joseph Fryan. I represent the appellant Letitia Baldwin. This appeal arises from an action to enforce a prenuptial agreement between Ms. Baldwin and her now deceased husband. The specific obligation in the prenuptial, which is the subject of this appeal, is an obligation that provides that if the wife survives the husband and the parties are not married at husband's death, the husband shall provide in his estate planning documents or otherwise, for wife to receive $1,600 per month as long as she shall live. Now, in this case, the parties were divorced subsequent to the execution of the prenuptial, and the husband died prior to the onset of this litigation. By way of background, the $1,600 replaced a military pension that Ms. Baldwin received from her prior husband in the approximate same amount, which was forfeited upon her remarriage to Mr.
Counsel, one issue that I have wrestled with a little bit, just reading the language of the contract, is, and I'm just interested, how do you think, what are some ways in which the appellee could have complied with this provision in your view? And I think the hard part is, right, it says it doesn't provide a specific amount, but it says as long as she shall live. So how, and there may be more than one way, right? But give me a couple of examples of how the appellee could have complied.
Your Honor, the appellee could have complied with funding a trust and leaving the money in the trust with her children as a remainder beneficiary.
But counsel, I don't know, right? How much do you put in the trust? I mean, because it says as long as she shall live.
Right. Well,
so, help me out.
I'm sorry.
Help me out.
Take her life expectancy, multiply it by the times of the amount with cost of living increases, that will provide one methodology. Another alternative would be to provide an annuity that would make her the beneficiary for life. Or you could leave an excess amount in the trust with someone as a remainder beneficiary, which she could have exceeded.
Mr. Fryan, within the trust, the parties retain control of their own assets. Is that correct?
That's correct, Your Honor.
Okay. So, and there was that each party could have, they had full control over their assets without the other party to the previous marriage getting to exercise control over the other party's assets, right?
That's correct.
Okay. Another way to fund it would have been, and I think is probably more standard, would be when you're talking about a post-death, would be a life insurance policy that would then fund the trust or fund the continuing annuity. Is that correct?
That is.
And that wasn't contemplated or spelled out, or that wasn't anywhere in the trust. Is that right?
That was not required under the terms of the of the trust or the prenuptial agreement. The options remained with the husband as to which vehicle he would choose to accommodate his obligation on this.
So doesn't that render meaningless if you're going to commit the decedent or the decedent's family to continuing to fund this annuity, but yet giving the decedent prior to his or her death total control over the assets? Doesn't that kind of render that portion of the trust meaningless?
Your Honor, I don't think it does. It provides an independent obligation upon the husband, subsequently his estate, and the trust under the terms of the amended final judgment of dissolution to provide this support. If for whatever reason the husband does not provide this support obligation, that would be a breach of the terms of the prenuptial agreement, which should support a judgment against him. Now,
Okay. So when would that breach take place? Would the breach take place prior to death when there's a realization that you're not going to have enough capital to fund the annuity? Or is the breach going to take place after the death when there's a realization, like in this case, that there's not enough principal capital there to then initiate the paying of the annuity?
well, in this case, Judge, presumably the breach occurred when no arrangement had been made, and within the 5 months preceding his death, all funds were transferred out of the trust.
Even though that was within his full power to do whatever he wanted to do with the proceeds of the principal of the trust.
And if you would, the breach matured when the death occurred and he hadn't made the arrangements. Now,
Counsel, is there a way to read those two provisions and give effect to both?
I think so, Your Honor.
Walk us through that.
Sure. He has an obligation to provide this support. During his lifetime, he can use his funds as he deems appropriate. So if he uses those funds in a manner that is not improper and there are no funds left in the trust at the time of his death, he is still in breach because he hasn't provided, and the wife should be able to pursue a claim against the estate, or in this case, under the trust, under the amended final judgment. Now, what remedy she's going to have against the estate and the trust is going to be dependent upon the manner in which the funds were taken out of the trust.
That's an issue that's not actually before us, right?
I agree with you. That's not actually before you, but it emphasizes the significance of the entry of a final judgment in favor of the wife against the estate and the trust.
So let me ask you this. So, it sounds like you're saying that the way to read these two provisions together is sort of along these lines. Hey, look, former husband can do whatever he wants to with his assets. He can set them up how he wants. He can create a trust. He can buy insurance. He can do an annuity, or he can do something else maybe that we haven't thought of. And former wife has no control over how he structures it. But what you're saying is, regardless of all that, he still has to provide the revenue stream in some way or another upon his death.
And his failure to do so exposes his estate and the trust to a final judgment, together with whatever remedies may subsequently be pursued by her. That was the bargain for consideration. Just because his money was transferred out in 5 months before, that doesn't excuse his non-payment. Respectfully, I think those are separate and independent terms of the contract. He had an obligation to provide, and he breached that. He did not provide. And that's the basis, essentially, of the claims in counts 1 and counts 2. And that should be a basis, in this case, Judge, for a denial of the motion for summary judgment. To read the prenuptial agreement otherwise there is no consideration coming in favor of the spouse. That was the agreement the parties reached. And it is appropriate that a judgment, in this case, that a motion for summary judgment should be denied because of his non-compliance with that obligation, and ultimately that the spouse should be able to pursue the claims against the trust and against the estate. I won't go into the nature of those claims, but I do not read those as being inconsistent. It essentially is no different than a unsecured indebtedness where one party agrees to make certain payments, but then transfers their money away before making their payments. The creditor still has a claim against the obligor, and when the claim is reduced to judgment, can pursue remedies against the obligor. Using that analogy, Ms. Baldwin would be the creditor. A commitment was made to her under the terms of the prenuptial that they would provide for it, they being the husband and his vehicles. That was breached. They did not provide for it. And as with any unsecured creditor, she should be able to reduce that claim to judgment and proceed with whatever remedies she has available against the estate and against the trust. To suggest otherwise is akin to the argument that an unsecured creditor will have his claim defeated just because he didn't take collateral or take some matter to ensure that the obligor was going to honor their obligation under the terms of the agreement.
So your view is basically, if I'm understanding it, is this: whether the decedent, the ex-husband, divested himself of his assets 5 months before he died or what have you, that's neither here nor there, because he's entitled to do that. But your position is, okay, if he chose to do that, he still had a bill to pay each month of $1,600. Let me go to trial. Let me put on evidence that my client's life expectancy is another 10 years and 1,600 times 120 months is X dollars. I would like a judgment for that amount of money based upon the evidence, the competent, substantial evidence at trial. Whether I collect it or not, it doesn't matter. Well, I mean, you do collect it, obviously, but I shouldn't be precluded from asking that based upon the fact that he chose to defund the trust, which is his right. He doesn't get to then avoid the breach.
Exactly.
That's your argument.
Exactly. His dissipation of the funds is not an affirmative defense to his breach of his obligation under the.
In other words, counsel, yeah, I mean, and I just want to make sure I'm understanding your position. I think I am, but essentially you're saying, hey, look, it's not a problem that he defunded the trust down to, what was it, $100 something at his debt. That's fine under the prenup. But what is not okay is that he didn't then provide some alternative vehicle to actually provide the funds, right? So you're saying he could have defunded this trust all the way down to $0, no breach, so long as he had also at the same time provided the annuity.
Exactly.
Okay.
Exactly. And his failure to do so constitutes the breach, which precludes the summary judgment and is a basis for me to pursue upon the claim, which, as you point out, the other remedies that may arise from that are not before the court at this time. But that's the essential argument. It's akin to a creditor-debtor relationship. And just because the debtor has dissipated their funds, that doesn't preclude the creditor from getting a final judgment against.
Well, you kind of, your third issue is the undue influence. Is that kind of gone by the wayside in the sense that, okay, so we don't have to discuss that because he apparently went to the lawyer to say, can I do this? And he did it.
I'm not pursuing that at this time, Judge.
Okay, thank you.
And Judge, unless there are other questions from the panel, I will sit down and reserve my 5 minutes for the conclusion.
Okay. All right, is it Mr. Roche?
Yes, Your Honor. Thank you very much.
You may proceed.
I may please the court, Clay Resch from the law firm of Sheffield, Lohman, and Wilson, here on behalf of the appellees, Mark Harris's trustee, personal representative of the estate. Addressing some of the questions that the panel has raised to Mr. Frine, the options for funding the trust were actually raised in a previous lawsuit. These were part of the divorce proceedings between Mr. Harris and the appellant. In fact, Mr. Harris's attorneys in those proceedings asked the court to require Mr. Harris to purchase a life insurance policy because they did not believe that a revocable trust was appropriate. And specifically, what they argued.
The language of the prenup wouldn't have supported that, correct?
That's correct, Your Honor.
Because the language of the prenup says, hey, look, you know, he controls his assets completely, right?
That's correct, Your Honor.
In other words, I don't think she's arguing that she had a right to tell him how to provide the revenue stream, at least not now.
Well, the argument for the breach is that Mr. Harris did not do anything to secure the payment, to ensure that funds were available after his passing. And that obligation is not within the terms of the prenuptial agreement. It doesn't appear. The actual language of the contract that obligates Mr. Harris to act provides that he shall provide in his estate planning documents or otherwise for Ms. Baldwin to continue receiving the monthly payments. And that is exactly what he did. He placed in his trust.
Counsel, let me challenge you. I mean, I think that's the issue, right? I mean, that you sort of just glossed over the issue, the entire issue in this appeal, which is, does that language entitle the appellant to a document that says, to an unfunded document that says she gets $1,600 a month, or does it entitle her to actually receive the monthly payment?
What that document requires, what the prenup requires, is for Mr. Harris to provide in his estate planning documents or otherwise. It is absolutely expressed in there for her to continue to receive the payments. It does not have a separate requirement for Mr. Harris to ensure that funds are available to continue making the payments. And that is the distinction.
I guess that's where I'm struggling to separate the two. I mean, I really am. So how do we separate? I mean, essentially what you're arguing, and maybe it's your best argument, but essentially what you're arguing is this language only required him to write some words on a meaningless document, but then not fund it.
No, Your Honor, that's not the case, because the revocable trust was an appropriate way for Mr. Harris to provide in his estate planning documents for her to continue to receive the money.
Absolutely, but it was unfunded, right?
At the time of his death, it was, but it was not always unfunded. If Mr. Harris had been struck by lightning 2 years prior to his actual death, there would have been assets in that trust, which would have allowed for payments to Ms. Baldwin. No, it's essentially a situation.
That's not when he died.
That is not when he died. Those are not the facts of our case. But
doesn't the provision seem to operate upon death? It sort of says, and the parties are not married at Henry's death. That's what it says.
Correct. That is what it says. But the provision requires Henry to take steps prior to his death to provide his estate planning documents or otherwise for her to continue to receive the payments. So, you know, that provision does start to operate when he dies. But he has to take steps.
He actually took the opposite steps by defunding the trust, right?
Well, I disagree, Your Honor, respectfully, because he went to an attorney and he got his estate planning documents in order to provide for Miss Baldwin to continue receiving the payments.
He just didn't get the bank account prepared to do so, correct?
That's correct, because there's nothing in the prenuptial agreement that requires him to do so.
Well,
again,
I mean, it says that he shall provide for her to, quote, continue to receive the monthly payment. In other words, it doesn't say that he shall provide. It says he shall provide for her to continue to receive. Isn't that to continue to receive kind of an important part of the provision?
It is an important part, but that ignores that the provision actually says how he shall provide for her to continue to receive. So in reading it that way, by skipping in his estate planning documents or otherwise, you're essentially writing out a portion of the contract which directs Mr. Harris, hey, how do you provide for her to continue to receive these payments in your estate planning documents, which was precisely what he did.
Or otherwise, right?
Or otherwise, certainly he had other options
So
available.
he could have done it, as counsel argued, he could have done it in an annuity.
He certainly could have.
That's what otherwise means, right?
That's correct, Your Honor. He had other options.
Well, tell me how that phrase in his estate planning documents or otherwise, which seems to me to be quite broad, how that changes the provision that says that she to continue to receive the monthly payments.
It gives him the option. It gives him some direction as to how he should provide for her to continue to receive the payments. So,
right, but she needs. I guess the point is she needs to continue to receive them. Do you agree?
No, Your Honor. This does not require her to continue to receive the payments. It requires Mr. Harris to provide in his estate planning documents or otherwise for her to continue to receive the payments.
And you're saying he did that by providing it in a defunded trust.
He did that by providing, at the time the trust was set up, there were assets in it. He did that by providing for her to receive those assets. The fact that there were no assets at the time of his death is unfortunate for Ms. Baldwin, but it is not a breach of Mr. Harris's obligations under the prenuptial agreement. He complied with the express terms of that agreement by providing in his estate planning documents for her to continue to receive the payments. The argument that the appellant has made as to securing the funds via annuity or life.
Let me ask you this: when do the estate planning documents come into play? Do they come into play at his death?
No, because he couldn't execute the estate planning documents at his death. He would have had to do those prior to death.
No, I didn't ask you when he executed them, right?
Okay.
When do they take effect?
Oh, they take effect upon his death, certainly.
Sure. So doesn't that cut against your argument that, well, he could create a trust 10 years before his death, and at the moment he created it, it was funded, but then right before his death, he takes all the money out of it, and that's fine?
No, I don't think so, Your Honor, because you don't actually know when you may pass. I mean, he could create the trust, and before it's funded, sometime in the 15 minutes between creation of the trust and transferring assets into it, if he has a heart attack.
But that's not what happened, counsel. He didn't die while it was funded. He died 5 months after defunding it, and almost entirely, essentially entirely. So I guess the question simply becomes: does this provision operate? Are we supposed to look at whenever he created the trust, which might have been, 10 years before his death, or do we look at does this provision trigger at his death?
Your Honor, he satisfied this provision when he created the trust, which provided for Ms. Baldwin to continue to receive the payments. That's when he satisfied his obligation under this provision of the prenuptial agreement. Again, there is
except
nothing
for that. Okay, all right. Do you have any additional analysis based on the actual language of the contract to support that argument?
Certainly, Your Honor. As was pointed out previously, there are other provisions that allow Mr. Harris sole control over his assets. Those are paragraphs 3 and 4A of the prenuptial.
And why is your opposing counsel's interpretation not the appropriate interpretation? Which, in other words, shouldn't we give effect to both provisions instead of reading one and out of the agreement?
Well, Your Honor, respectfully, I do not believe that you'd be reading one out of the agreement. The way to give effect to both provisions is to do exactly what Mr. Harris did: provide in his estate planning documents for her to continue to receive the payments and allow him to have full control over his assets. If you look at that section 3, it is very broad. It allows him to not just sell or devise or dispose of, but to give away, to get rid of, to gift, to completely dispose of all of his assets. That does not create any right on the appellant's part to prevent him from doing that. And so
if we read 10E to require not just words on a page of an estate planning document, but also actually providing the revenue stream, actually providing that she can, quote, continue to receive the monthly payment, then would you still argue, if that's the interpretation of 10E, would you still argue that he was entitled to defund everything based upon that other provision?
Well, Your Honor, respectfully, I would disagree with that interpretation. I believe that's adding in a provision that's not part of the
No,
contract.
I understand you disagree with that interpretation. I'm asking you if we interpret 10E in that manner,
We disagree with you.
right?
Understood, Your Honor. So if the court were to read 10E to require, an income stream, again,
Actual payment, yeah.
actual payment, again, I don't believe that is going to allow Mr. Harris the authority to, or the ability to give, devise, or otherwise dispose of his assets. You have to have some amount to pay for a life insurance policy. You have to buy an annuity. You have to set aside funds in a segregated account. That is interfering with Mr. Harris's right to do whatever he wants with his property under Section 3 of the contract.
So essentially at that point, you would say 10E has no effect.
No, Your Honor, I'm not saying that 10E has no effect.
Tell us what effect 10E would have under your interpretation of his right to do whatever he wants with his assets.
So 10E has the effect as written. He can provide in his estate planning documents.
He can or he shall?
It says he shall provide in his estate planning documents for her to receive, her estate planning documents or otherwise for her to continue to receive the payments. So that is the provision in there. So that is exactly what Mr. Harris
But
did.
you just disagreed with my proposed interpretation of it. And I said, for purposes of our discussion, just entertain me here, right? For purposes of the discussion, if 10E means that he had to actually provide some vehicle for $1,600 a month for her to actually receive it, then how do you think that the provision saying that he has control over his assets would apply to 10E under that interpretation of 10E?
Okay, thank you, Your Honor. I understand. I don't think that you can reconcile those two under that hypothetical. I think that shows the flaw in appellant's argument. If there is a requirement for him to secure payment, he is no longer able to dispose or deal with his own property as he wants. It renders that section.
Well, he could decide whether he wanted to put those funds by purchasing an annuity versus a trust.
Sure, he certainly could, but once again,
He could also decide whether he wanted to do an insurance policy versus a trust or an annuity or some combination thereof, correct?
He could, but again, that is encumbering his funds. He's no longer free to do whatever he wants.
Well, is that, I mean, that's what 10E does under our hypothetical, right?
That's what 10E does, and that's why it would render Section 3 just surplusage. And
which one is more specific? The provision that says he has sole control over his assets, or the provision under 10E that says he shall provide for her to continue to receive monthly payments? Which one's more specific?
Well, Your Honor, they deal with somewhat different things. I would say that the more specific provision in the document is Section 3 because it says he can do whatever he wants with his own property, and it lists.
Doesn't that apply to all of his assets, which were substantial at the time, correct?
It applies to all of his assets, and if you look at Section 10E,
and 10E would only apply to the $1,600 a month revenue stream, correct?
Correct. Section 10E applies to, well.
So based on all that, your position is that 10E is the more general provision?
It is as you read it, because it says that Henry shall provide in his estate planning documents or otherwise for her to continue to receive the payment. There is a whole universe of that otherwise, as the court has pointed out, as to how that could have been done. Mr. Harris,
so if we conclude that these two provisions are hopelessly conflicting because we think 10E provides an actual revenue stream of $1,600 a month, but then we agree with your conclusion that then the two provisions are hopelessly in conflict, what should we do then?
Your Honor, under that circumstance, the court should give effect to paragraph 3 that allows Mr. Harris to.
Well, let me ask you this: is summary judgment appropriate at that point?
Your Honor, at that point, I do believe summary judgment is still appropriate. We're talking about the interpretation of a contract. It is.
Well, you just said the two provisions are hopelessly in conflict.
Wouldn't that require the taking of evidence to find out what the intent of the parties was?
Well, Your Honor, I'm sorry. Under the hypothetical that we were traveling under, it was under the impression that conflict had been resolved because the $1,600 a month, this court has found hypothetically, again, that the $1,600 a month is required in Section 10E.
But then you said under that interpretation, the two provisions would be hopelessly in conflict. Isn't that what, did I misunderstand you?
No, Your Honor, in that situation, yes, they absolutely are in conflict.
And so that with that answer, then I would ask you, how is summary judgment appropriate then? If the two provisions are hopelessly in conflict, is summary judgment possible in that situation?
Your Honor, where you have the two conflicting provisions of the contract, of course, the court has to try and read them in harmony, which again, I think is why
We've already established they're hopelessly in conflict under this scenario.
Keep circling back. They're conflicting. It's ambiguous and we can't put them together. So
It's
isn't that,
impossible.
aren't you answering the question that said if it's ambiguous, you then have to find out what the intent was, which would mean you'd have to have evidence, which would mean you'd have to weigh it, which would mean summary judgment's inappropriate. I think that's what Judge Eisner
Yes.
was trying to get you to acknowledge, that that's just a basic tenet of the law, whether it applies to this case or all other cases when there's ambiguity.
Absolutely, where there's ambiguity, summary judgment would be inappropriate.
And if it's if they're hopelessly conflicted, doesn't that make them ambiguous amongst themselves or interlocking between themselves?
Well, Your Honor, I believe under the scenario that's been set forth, that yes, there could be an argument that there's an ambiguity within the contract that would require extrinsic evidence of the party's intent. Now, that was not raised by the appellant below. It was presented to the court as a pure question of law. And of course, the canons or tenets of contract construction require us to try and give effect to every provision so that we are not reading a provision out of the contract. It also requires us to try and harmonize the various provisions within the contract, which is why I believe that the interpretation or the reading of Section 10E to require that income stream or that monthly payment is not the correct interpretation. Your Honor, as I started to mention, this actual argument was raised in 2008 and 2009 as part of the divorce proceedings. Ms. Baldwin's attorneys tried to get the judge in his final judgment to order Mr. Harris to obtain a life insurance policy to secure the benefits, and Judge Dickey recognized that was
But
not
counsel,
part of
that remedy would well, the way I read the contract, that remedy absolutely would have violated the prenup.
the requiring of a life insurance policy.
Requiring a
Certainly.
specific structure for 10E would have been prohibited under the prenup.
I agree, Your Honor, but I think it's broader than that.
How is that relevant here?
Well, the argument was not simply to provide an insurance policy. The purpose was to secure the benefit. That was what was argued. It wasn't simply, hey, he should get an insurance policy. It was get an insurance policy to secure the benefit, to make sure the money is there so that he can continue to make payments after he passes away.
But the prenup doesn't allow her to secure, in that sense, right? It doesn't allow her to secure the payment in that sense that you're talking about right there.
That's correct.
Correct.
It only
It
requires.
essentially allowed the appellee to breach the agreement if that's what he decided to do potentially, right? Depending on how we read the provision. But it did not allow her to come in beforehand and guarantee performance by dictating how he was going to comply. Correct?
Correct, although I would disagree with the characterization that it allows him to breach the agreement. I mean, if you look at what Mr. Harris did, he provided in his estate planning documents for her to continue to receive the funds.
Well, I mean, Judge Dickey in 2008 basically said that's not in there. It doesn't say you must have life insurance, so I'm not going to force that into the agreement. You guys figure it out if and when the time comes, which is the time now.
Yeah, I think Judge Dickey actually went beyond that. He said that I'm not going to rewrite the agreement, and that the remedy would be an action against a lawyer for drafting a bad agreement, but that he was not going to require Mr. Harris to take steps to secure.
That doesn't mean he's right just because he said that either. I mean,
I'm sorry, Your Honor?
that doesn't mean he's right just because Judge Dickey said that 12 years ago. He's right in the sense that if you don't put it in the agreement, you have to have life insurance. He's not going to add a paragraph in there and said, oh, by the way, I'm now going to, get my pen out and add a paragraph.
That's
That doesn't
correct.
mean that doesn't mean, okay, Mr. Harris, Katie barred the door. You can do it, defund it, when, as you're getting near the end of your life, go ahead and defund it and she's out of luck.
Well, again, what was asked of Judge Dickey was to require Mr. Harris to secure the funds. The proposal for that was life insurance, but
He
whether
could
it's
say, don't
annuity-
worry about it. I'll take care of her. I would never do anything like that to her. It's not part of the agreement. I don't want to pay any more money for life insurance. Have a nice day.
Well, Your Honor,
And like you
Unfortunately-
said, the guy could have died, on the way to defund his money, defund his trust. He could have died on the way, and then I guess we wouldn't be here on this case. I guess we'd still be here, but
well, Your Honor, I would point out that that Judge Dickey did have the benefit of knowing that the revocable trust had been set up, and it was being argued that the revocable trust was not an appropriate vehicle to secure the funding. And Judge
Well,
Dickey,
counsel, that's an entirely different argument than what we have here. And I'll just ask you this, and you are out of time, but I'd like you to answer this question succinctly, if you would. Paragraph 10E, that provision, was it possible for 10E to be breached at the time of the dissolution proceeding that you're talking about right now? In other words, let me put it more specifically. Had your client had death occurred?
okay. So at the time of the dissolution proceeding, you could not necessarily breach 10E because they were still married at that point in time. You have to
Right,
wait
and he was still alive.
and he was
correct.
still alive. Yes,
So
Your Honor.
10E was not at issue in that proceeding, correct?
Well, Your Honor, I would respectfully disagree with that. 10E was raised by appellant's counsel, and it was brought up, and the request was made to secure the funds, and it was denied. So, thank you, Your Honors.
Okay, Mr. Fryan?
Just briefly, Judge, the language of the provision creates a mandatory obligation on the part of the deceased husband. He shall provide. There is what I go into detail, a restrictive phrase that gives him alternatives, in his estate planning docs or otherwise, but it's a mandatory obligation, shall provide. When he didn't provide, that constitutes a breach. And as in any creditor-debtor relationship, we should be entitled to pursue a judgment against the debtor for failing to comply with the mandatory obligations. To suggest that just by creating an estate planning document that doesn't provide that obligation is satisfied leads to an absurd interpretation with regard to this matter. And if the court doesn't have any further questions, I will conclude my argument.
Okay, thank you, counsel, for your argument.